Pepitone. This continues our Atlanta Divorce Law Group's COVID-19 series of We Won't Back Down. And typically on Monday evenings, we like to cover something that relates to how we won't back down from providing services for our clients and helping their lives move forward during all of this. And what's most pertinent tonight to discuss is the shelter-in-place order that came in from the governor of Georgia last week on April 2nd, where he basically told all of us to stay home, and not only essential workers and essential businesses could maintain business and operations. Now, that left a lot of confusion for a lot of people on what does this mean for leaving the home to go drop off or pick up a child that you share custody with another parent. So a lot of our clients or people who are co-parenting had questions on, can I leave the home for a drop off or a pickup for my child? Because sometimes these drop off and pick up locations, the way the parenting plans are written, are not specific to a home. They actually can sometimes occur in a public place. And that left people worried. So on April 3rd, the next day, thankfully, the governor actually issued a clarification and as a follow-up to his initial order. And I'm going to actually read the language that's pertinent to our conversation of child custody exchanges and what it says, because it couldn't have been more clear. He says that no provision of Executive Order April 2nd, 2001 shall limit, infringe, suspend, or supplant any judicial order, judgment, or decree, including custodial arrangements created pursuant to the laws of Constitution of the state or the laws of Constitution of the United States, nor shall any person use any provision of Executive Order 42-2001 as a defense to an action in violation of a judicial order, judgment, custodial arrangement, or decree by any court created pursuant to the laws or Constitution of the state or the laws or Constitution of the United States. This paragraph does not attempt, nor shall it be construed, to imply that the governor in any instance has the unilateral authority to overturn any judicial order, judgment, or decree. So, Ashley, for us attorneys,
we're so long-winded.
Yeah, we're so long-winded, and there's so much language in there, but we're reading it, and we're like, in our office when it was released, we're all like, woohoo, you know, we have clarification, it's black and white, it's very simple, but let's break it down for our clients and families out there that don't have a law degree. Why is this so clear? Why is this so black and white to us?
Yeah, it's really good. It's not necessarily going to be the answer that everybody wants to hear, but it's very clear in that it's stating basically nobody can use this as an excuse not to continue to have a healthy co-parenting relationship with the other parent. So basically, I think what the governor was trying to do, and I want to point out that it came out just a day after the shelter-in-place order.
Pretty impressive.
What's that?
That was pretty impressive, how quickly they clarified it.
And just in seeing all the communication going back and forth on the different Georgia family attorney groups that I'm a part of, I think it had a lot to do with the family attorneys in and around, especially the Atlanta area, being very vocal and getting in touch directly with the governor's office and saying, hey, we already are getting questions about this. You've got to issue something that clarifies it for people. I think that people are more concerned not actually with the fact that the custodial arrangements might say, you know, meet at the Quick Trip or meet at the police station to exchange. But what I've been hearing a lot of is my ex-significant other, or, you know, the other parent of my child does not take this social distancing as seriously as I do. So can I say, you know, our kid's not going to go to your house until this is lifted? No, you can't, you really can't do that. And it really just is another aspect of how a healthy co-parenting relationship means that you're not going to necessarily like the way the other parent parents 100% of the time, but you've got to release a little bit of that control. And the governor's just saying, basically, don't use my order as an excuse to try to get more of that control. So no, don't try to withhold your children, even if you're not consciously trying to do that. It won't look good on you if you're going to tell, the other parent, I think this is a bad idea. Definitely try to work through it. Try to come up with another solution to limit the amount of exposure the child has to outside persons and places, for sure. But it won't put you in a good position later on. It could open you up to a contempt action later on.
Especially when the governor was so black and white about it. And this, he's being so clear that this is not to be used to violate judicial decrees regarding custodial arrangements. When he's being that black and white about it, if you do use it for that reason, you're possibly setting yourself up for a contempt action when this is all over.
I think so. I think, whenever I have somebody approach me with a potential contempt action, I always want to say, is it worth going after them when really what you're going to get is probably attorney's fees paid for and a slap on the wrist, so don't do it again. Hopefully it won't breed too many contempt actions because the courts hate them anyway.
Right.
But you just don't want to expose yourself, and it's not good for the children either. So,
well, we should point out, and that I love that you said that it won't breed too many contempt actions, because there are definitely people that are over litigious and will use any opportunity to go and file a contempt, and it doesn't create a healthy working with communication relationship with the co-parent. And so it's important to point out that contempt actions, they're looking at a pattern of behavior. Right. So you're not going to be able to use this one instance anyway and get a whole case out of it.
But if you're on the other side of it and you've been the parent who's been alienated from your child, or you feel that the child is being withheld from you and you can show a pattern, and this is another, notch that you can add to that pattern, then I think it's different. You don't want to be the boy who cried wolf.
Right.
For one instance, isolated to a unprecedented time when but you can certainly use this as an example of a pattern.
Ashley, would you, in your opinion, think there are any exceptions to this where a parent could use the shelter in place still to withhold visitation or custody exchange?
I think that the circumstances are going to be very, very limited in which you could successfully argue an exception. It's going to be on a case-by-case basis. So if you have a thought in your mind, definitely contact a family law attorney that's local to your area and ask them what they think. But I think if there are any exceptions, it's going to be situations of an extreme nature where, maybe the child themselves is medically fragile, or maybe somebody else in the household is medically fragile, and the other parent or the other parent's, current spouse is in the medical field and is working in hospitals all the time and is potentially exposed. I think in a situation like that, perhaps, but I'm not going to give a blanket, you can do it if your situation fits these parameters. I think you have to be really, really careful. Not to assume that, this doesn't apply to me. And I think that, like I said, it's a case-by-case basis. It's going to depend on your circumstances, your situation. It's going to depend on your judge. And how many of these cases they end up seeing.
Right.
And how tired of them they get.
There'll be quite a bit when all this is done, unfortunately.
Yeah.
So just to wrap up this part of the conversation, because we also want to talk about the just order that we received hours before this tonight from the Chief Judge of the Georgia Supreme Court. But to wrap it up, it's pretty black and white, guys. The custodial arrangements continue as scheduled. They need to really continue the parenting plan. If you were thinking the shelter in place order was going to be a way to keep the child at home and not go through with your custody exchange, it isn't. So continue that. and communicate with your co-parents. That's really what the governor is saying. He's saying that he's not overriding anything the judges have told us through the parenting plans and divorce decrees that we should be doing already.
And just to clarify and piggyback on that a little bit real quick, it's pretty standard language in, I think, every parenting plan in Georgia that I've seen that states that you can go outside of the parenting plan and come to an agreement on your own and be flexible with each other. So if you do come to a different arrangement, I don't want anyone out there thinking, well, this is what the parenting plan says, and the governor issued this order that says that we can't change the parenting plan based on, no, if you are in agreement, both parents are in agreement to do something different. If, for instance, one of the parents is a doctor and they don't want to expose the child, you can choose to do something different. You can choose to have a new temporary arrangement on your own. It won't be enforceable in court, but make sure you get it in writing that you both agree to this. An email or a text message is, should be fine. Make sure you both agree. And if you both agree that something other than what is in the parenting plan is what's best for your family and for your child, then you can certainly do that. So I don't want any, it's a bar on unilateral action, right?
Yeah.
That's all.
I thank you, Ashley. I think that's very important to clarify, because at the end of the day, co-parenting is really about the parents making these decisions together and not using their own instinct for using their own instinct for what's best for their child, and bringing that to a communication that's healthy and functional for the child. And as long as they're doing that, the court doesn't need to intervene, but like you said, document it. Okay, so as many of us are aware, since March 14th, we've been under a judicial emergency order from the Chief Judge of the Georgia Supreme Court, basically stating that only essential hearings and essential judicial business would be conducted. This was as of earlier today. I don't know the exact hour, but it was in the afternoon. The Supreme Court Chief Judge issued an extension of that order, where that judicial emergency order is now in effect until May 13th, 2020. What does this mean, Ashley, for our family law or divorce and child custody clients?
I would say it shouldn't mean too much. That's kind of not 100% true. To me, it's an opportunity. It's an opportunity for those who are not in an emergency situation to be able to use the ADR, the Alternative Dispute Resolution, resources that are available to us. But what it means essentially is that nobody's getting in front of a judge for anything that is not basically an emergency, where somebody's in danger, such as a family violence hearing. Those are still going forward. Any kind of juvenile dependency cases, so where DFACS has been called in, the child is being removed from the home, those are still going forward. And then certain criminal matters where the accused right to liberty could be infringed upon if they were not afforded like a bond hearing. Those are going forward. Anything that doesn't fall within those and maybe a couple of other exceptions is not going to be heard in person. In Georgia, we've seen some use of video teleconferencing and regular teleconferencing for hearings, particularly in Fulton County. Fulton has been really good. Some of the judges' offices have been quicker to adopt the video teleconferencing than others, but it's worked really well. I love it and the clients love it, honestly, because I don't have to spend an hour driving into Atlanta and then an hour sitting there waiting to be called and then an hour driving back. We just sit on our computers.
Yeah, this is really a huge opportunity for some of the inefficiencies of not just the law practice for us attorneys, but just the system for our clients. They drive all the way to downtown Atlanta for a Fulton County status conference. They're on a calendar call. They're there all day long. They're paying their attorney by the hour to get in before a judge just to have a quick sentence in and out. And they took off from work. They took time away from their children. They did that. This emergency is letting us see that a lot of these things could have been done through video conferencing or teleconferencing. Actually says here, with regard to matters not deemed essential functions under the statewide judicial emergency order, courts and litigants are encouraged to proceed to the extent feasible and consistent with public health guidelines. For example, through the use of teleconference, video conference to reduce backlogs within the judicial emergency ends. I find that to be, if the judge, a lot of the judges and the county courts, they follow through with that encouragement, it could change our system for the better, even when it's
it's forcing the judiciary to come into this decade or even last decade.
Right, for sure.
Which is, it's really, really, really exciting and encouraging to see. So yeah, I haven't encountered a ton of frustration yet. We're still a little early in this. I mean, the shelter-in-place order just came out on the 2nd. We have been under a state of judicial emergency since March 14th, so that has been in place a little bit longer. But I've had 2 so far video mediations. I had one of them today.
And you've had amazing results with these.
Both of them settled way faster and easier than my.
So Ashley, what do you, so this saves the client money when we're settling these cases and mediation's not going on all day long.
Right.
What do you think is the difference between them being in person and now in virtual, that they're settling faster and we're saving the client attorney's fees on that?
Yeah, I think it's a couple things. I think it's much more efficient. You know, we're not sitting around looking at each other, ordering lunch. It feels much more, we're getting down to business. This is what we're here to do. It feels less like just a chat session, with, a therapy session I hate to say that because I know that so much of the ADR process and being able to speak to the mediator really is cathartic. But for some reason, when you're talking like this on a screen with somebody, even though it really does feel nice and personal and it's been really effective, I don't think people are quite as comfortable as they are in person, so much that they want to sit and chat for hours and hours.
So they get straight to the point of what they get to the point
faster. Yeah, and by settling at mediation, any kind of mediation, by taking that power into your own hands, you're ultimately going to be so much happier with the result that you get than you would have been if you went to court. I think a lot of times, even if you got everything that you asked for in court, you feel better about it when you have some power,
right?
And saying, yes, I'll give that up, rather than a judge saying, you're going to give this up.
Yeah.
So I think that I'm surprised at how well, I will be honest, I'm surprised at how well video mediation is working, but it's worked better and faster than in-person mediation for me. I might prefer video mediation.
Well, that's fantastic, because I think it's going to be the way of the future for a lot of cases. Of course, though, it still relies on the client's hand. I think we're still at a point where if somebody wants to opt out of it, they can opt out of it. But for so many, it's going to save time and money. And it's going to save that whole trying to get coordinating all those people's schedules, the mediator schedule, the opposing counsel, your attorney's schedule, your schedule, and your ex's schedule. So I think it's going to create a lot more movement for people. One thing that I think is going to be really important, though, for us to clarify for people who aren't attorneys, they're not practicing, for our clients and for families out there. And I get this question a lot when I reach out to our clients to check in on them. They're thinking this judicial order means that the judges have taken off on vacation.
Oh.
They're thinking that this judicial order means that the clerks in the offices are not filing. We have still been filing quite a bit, whether it's been modification, divorce papers, contempt actions. We've been, the past 2.5 weeks, we've been filing away, and we've received orders signed by the judges in the past 2.5 weeks. So would you mind just kind of like giving people some comfort on that the courts haven't shut down? It's just they're not holding these hearings for as often as they used to.
No, the judges are still there. Their staff is still working. I don't know how many of them are in the courthouses, but I know their staff are still working because I communicate with them on a daily basis all day long via email. What is happening less or slower is the actual filing of the documents by the clerk. So the work that's being, only because they're working on a skeleton crew, they don't have,
Right.
Gwinnett, for instance, there's probably, I don't know, there's 10 windows, I think, in the civil filings division. There's probably at least 10 clerks working every day. They maybe have one or two. And so we're e-filing still, but that e-filing still has to go through a process where an actual human being looks at it, makes sure that it, that whatever filing fits all of the requirements, and then they can accept it. So that is all happening a lot slower. But we're also, when we file anything, we're sending a courtesy copy to the judge's staff, so the judge gets it right away. None of that is slowing down. So what you see on the court website, and you look at your pleadings online, you might not see that your lawyer has filed something. But if you talk to them and you ask them and they say that they have. It's just not showing up yet because the court staff isn't there. The judges and their staffs are still there. They're still working incredibly hard, probably harder now than they've ever worked before, to make sure that the backlog, when this is all done, is not as bad as it could be.
Yeah.
They're really, I mean, I can't say enough for especially the judges, our local judges, staffs have been incredible to work with right now. So, and I just want to say that Lauren Tanksley is mentioning that she loves video mediation too.
Oh,
so,
yeah. She's with the times. She's on top of everything. Well, yeah, go ahead, Ashley.
I can't remember what I was going to say. I do that all the time.
Well, thank you so much for helping us clarify. There's just so much was issued. I mean, it's been since I think April 2nd, so the governor sent out that shelter-in-place order. There's been so much happening, and I think the schools, at least in Fulton County, and I know most of the other counties, shut down for the rest of the semester. So we know a lot of families are going through a lot of change really quickly. We're here with you. We're going through them as well, and we're here to stay on top of them and be responsive to them and not reactive to them. And here at Atlanta Divorce Law Group, we're using them in every way we can as an advantage to create more movement for you and not make you feel that life has to just come to a complete stop because of this. There's still ways that we can find control and create movement and create resilience and strength through all of this that we're all going through and having this shared experience. Doesn't mean that it's easy. Doesn't mean that it's not painful. Ashley, you have little kids. I have little kids. So and even people that don't have little kids are feeling just isolation. So hang in there, guys. We're here for you. We won't back down of helping you get through this, and we will all come out of this more resilient and stronger together. Thank you so much, Ashley.